I always start with a little bit of an update. The update tonight is going to be short. I was hoping to have a much more detailed update for everybody. But as many of you know, there was a hearing scheduled for this past Friday. Unfortunately, Judge Stern, who is presiding over this case, came down with the flu, and so that hearing had to get canceled. He's still not back, so we have not yet rescheduled it. But I will be happy to, for those of you who did not get a chance to either look at the website or hear about what my recommendation was, I'll give you a quick summary of my recommendation, which was going to be heard on Friday, and I anticipate that it would be approved. Nobody was objecting to it. And that is, there were two things I was specifically recommending to the court. One was with regard to monthly benefits and whether or not there would be an adjustment to those monthly benefits. I asked the court to defer any recommendation which would cut anybody's monthly benefits for at least another 90 days. The reason that I did that was for a number of reasons. The two what I'll call minor reasons are the market has shown some volatility lately, and I'm looking into asset allocation, but the market seemed to have corrected itself a little bit at this time, and nobody is worried at this time that we're heading into a bear market anytime soon. So I didn't think that the volatility, which if it becomes a bear market, would impact the assets negatively if we don't reallocate them. I didn't think that that was significant enough of an event to warrant an adjustment of benefits. The other issue was the drain on the assets that we have, the drain on the pension itself. We still have about 86 million. The bad news is we only have 86 million. The good news is that that's how much we had when I was appointed in August. And we still have that amount, even though we've been paying out about $850,000 a month in benefits, which means that the investments that we have for the plan have been performing to the point where it's at least keeping us at a break even. So we haven't really lost much money, even though we've made about 6 months worth of payments at this point. The two more critical reasons why I asked the court not to make an adjustment just yet. One is related to the litigation that I'm looking into with special counsel. We're still going through the investigation. Unfortunately, as many of you know, and it's been on the website and it's been in the news, we ran into some delays as a result of the various parties that we were looking for documents from. They weren't providing those documents in a timely manner. It forced us to go into court on at least 3 occasions, I believe maybe even 4, to compel those parties to produce the documents. There are 2 problems with that type of a delay. One, there's a delay in time. So if we were asking for documents on November 1st, but we didn't actually get the court to enter an order compelling them until December 15th, for example, we're already 45 days behind in terms of getting and reviewing those documents. The other thing is to the extent we had documents, while we are engaging in motion practice trying to compel, we can't be looking at the documents that we have if we're having to prepare pleadings to try to force the parties that aren't producing them to produce them. So as a result of all of that, special counsel is about 45 to 60 days behind on what we had hoped would be his review time frame. Excuse me. There's the reason why that is significant to me in terms of whether or not I'd be recommending an adjustment of benefits, and if I were, how much of an adjustment, is because if special counsel were to come and say, this is what we believe we can get in terms of a lawsuit, and this is what our potential recovery is, that number could be a very small number or it could be a very large number, and that would drive how deep of a discount or deep of a reduction of benefits, if at all, I would have to do. If he came back and said, I think we can sue these 3 parties, and if we sue them, I think it's likely we can recover at least X, and X is a very large number, I might not have to make an adjustment at all. If he comes back and says we can sue these three and I think we can likely recover X and X is a much smaller number, that's a different scenario for me. So without having that information, I wasn't comfortable asking the court to make an adjustment of benefits. And I feel that although 90 days we will erode more cash, I didn't feel like that was such a long time frame to wait to let you continue to receive the benefits that you're getting right now while we wait and see what that investigation does ultimately reveal. The last and most, I'd say the most technically critical issue that I had involves our discussions with the Pension Benefit Guaranty Corporation, which, if you haven't heard me say it before, is the federal, quasi-federal agency that insures pensions that are distressed and that are underfunded. This plan had been considered by St. Joe's for many years to be a church plan, and as a church plan, it falls outside of the Employment Retire Income and Security Act, ERISA, which means it's not bound by ERISA, and if it's not bound by ERISA, it's not insured by the Pension Benefit Guaranty Corporation, which I'll call the PBGC during tonight's discussion. I believe that there is a good argument that this plan actually, it was and is an ERISA plan now, and that as a result, if I'm correct on that argument, then PBGC would have to cover this plan. I'm in preliminary discussions with the PBGC. They know our position. They have not yet taken a position on our position. We have provided them with a large volume of documents which are supportive of that position. They've also subpoenaed their own records from St. Joe's and the diocese and other parties so that they can make their own independent determination. There's no time frame that the PBGC is bound by to make this decision. They know that we have a short time frame that we're working on, but at this point, I'm working with them to try to get them to understand our position and give us their reaction to what that position is. My concern on a benefit reduction is, if I am correct that this is an ERISA plan, I don't want to make a reduction to benefits, which would be a violation under ERISA, and it could potentially subject the plan to penalties, financial penalties, as well as potentially preclude or diminish insurance coverage from the PBGC. So rather than make a decision today that could potentially, I don't know if it certainly would violate, but I have enough of a concern that I don't want to test that water, where it would render me in violation of the plan. I don't want to make that act today until I have a better idea of PBGC's position. So rather than risk violations, rather than risk getting some penalty as a result of violating ERISA, I prefer, again, over the next 90 days to let ERISA kind of come to their decision as to their opinion on our position before I suggest anything. If they agree with me that this is an ERISA plan, or I do something that puts us in a position where we clearly assert that, I wouldn't be able to make those changes anyway, as far as I'm concerned, without doing much due diligence on making sure that we don't run afoul of ERISA's regulations. So those, in a nutshell, are the four reasons. The last two are a little bit more complicated in terms of strategy, but at the end of the day, what it means for everybody is that there will be no adjustment to benefits for at least the next 90 days. I reserve the right to ask the court for additional time as well. But notwithstanding that, as you know, I did form an advisory committee, and that committee continues to meet on a regular basis and discuss potential options if we did get to a point where we had to make cuts. But at this point, there's no recommendation from that committee, and there's no recommendation from me as to cuts. Status quo, whatever you've been receiving, you're going to continue to receive at least for the next 90 days unless something drastic or dramatic happens that would require me to run into court. That's recommendation number one that was going forward on Friday, will go forward, but when the judge gets back. Recommendation number two is, as many of you, if not all of you know, back in September, well, I'll start back in August, the court appointed me as the receiver for the plan. In connection with that appointment, the court says that everything must stop with regard to the plan. Nobody can do anything that would further diminish the asset or impair the asset. In September, the judge clarified that with regard to that stay, that it applied to new applications for benefits. So if you were receiving benefits before I was appointed, you continue to receive them. If you had submitted an application, but it had not yet gone through the full processing process, then it would be stopped where it was and not acted upon until further notice of the court. Same thing with new applications. You could submit a new application, your place in line would be preserved, the date in which you filed it would be preserved, but it would not be processed. In my pleading, which was going to be heard on Friday, I recommended to the court that that stop be lifted. So in essence, what that means is that if you have an application that was not fully processed by August 18th, which is when I was appointed, it will now start, once the court approves it, it'll go through the application process. That also applies to not only people who had applied that were frozen, but if you wanted to apply tomorrow or the day after that. So it's not just the ones that were frozen that are being released. It's anybody who wants to apply, they can apply and they can get their benefits. The process generally takes about 3 to 4 weeks. Because we have a little backlog, it may take about 6 to 7, I'm told. But once the court approves it, then the switch will be flipped and the benefits administrator will start to process those applications in the order in which they came in. And anybody who had applied or will apply will start receiving benefits in the same manner as they would have if it were processed in October and November. That's in essence the summary of my pleading, in a way that also gave you a bit of a summary of what's going on with special counsel, because we're still going through the documents. He and his firm, Max Wistow and his firm, believe that they're going to have a report for me within the next 10 to 14 days with some findings as to what they found through their review. By the way, the document review we have, I think our count was over 489,000 pieces of paper that we were going through. So it takes a lot of time. We have to touch every single piece of paper because the last thing you want to do is not look at something that ends up being something that somebody brings to the court to say this is why you're wrong. So we've got to look through everything. But in about 10 days to 2 weeks, he'll have the results of his review for me, and we're going to start talking about preliminarily what direction we want to move in terms of litigation, what would be prudent, who would be the people that we would pursue against, and what the likelihood of recovery is. Those will all be discussions between special counsel and myself. Unfortunately, I won't be able to tell anybody, including the judge, who I'm suing until after I file the lawsuit. I don't want to give anybody the heads up, and I don't want to disqualify the judge. So while you may all have questions, who are you going to sue? Who do you think it's likely to sue? I won't be able to tell you exactly who it is until I file the actual complaints against those parties. We're looking at everybody, as I've told you. Nobody is outside the scope of our review. And I can tell you that if we decide to pursue, it's because we think we have a pretty good chance of recovery, and it's worth pursuing to get that recovery. And if we don't pursue, it either means that we don't believe that that party has any liability here, or that they do, but it's just not worth the cost. What we could recover wouldn't be worth the cost of pursuing it. And with that, I'll open up the floor to any questions that anybody may have. If you could come to the microphone, please, so everybody can hear? Hi. Hi, Karen.
I don't know if this has already been asked, and it could have been because we're kind of into this for a while now. But when I chose my pension in 14, there was options that you could take, and you could do joint survivor or 10 years or whatever. And I took the joint survivor for my husband. So if I know you're not sure about everything, but if there was a chance that we were going to take a reduction, okay, would there be, because everything has kind of been changed now, like, would we be able to go back to our original, like, I would be able to take my whole pension like I would have done without doing the survivorship? Would I be able to go back to doing that? And then, like, we'll just say if it's $1,000, it would be, I would go up to whatever the amount is.
And then the reduction.
And then the reduction from that. But then I wouldn't have the survivorship.
Right.
Because if you felt as though we were going to have this down the line so that, this would be viable for my husband, then I would just probably keep it there. But if it's not going to be any chance of survivor, that I would rather go back to that.
I understand. Unfortunately, I can't tell you what the result is going to be right now. If depending on, let's say, if PBGC were to come in and give coverage, based on what we believe PBGC must do, if coverage is possible for this plan, then that would be something where I'd say leave it as is, because it'll be taken care of throughout the life of the plan and the life of you and your spouse.
Right.
The litigation obviously is much more speculative, and it's not realistic to think that litigation would result in making this plan whole. The question you're asking, though, is a little bit more technical, and quite frankly, I'll have to go look at the plan and talk to the benefits administrator before I answer it, because I don't know what the plan says about changing your election option after you've already gone through the process.
Right.
I would imagine, and I'm not saying this based on any information, just my common sense, I would imagine that if your circumstances were to change, that you might be able to ask for a change, because at the end of the day, it's your pension. But I don't know what the process would be, and even if my thought of common sense is actually common sense. I will look into that, though, and what I'll do is Julie and I will update the frequently asked questions once I have the answer to that, and we'll post that up on the website. Okay?
I'm hoping that ERISA thing
So do I.
Sounds like our best bet.
Yes.
Just say that the PGC picked us up
Yep.
and they found fault on somebody. Would you still go after that person or
If-
that organization or?
If anybody couldn't hear that, the question is, if the PBGC did step in and take over this plan, and that was the best option for the plan, and we had claims that could be brought against those other parties, would those still be pursued? The answer to that question is, quite frankly, I don't know. And the reason I say I don't know is because the claims would still exist, but the PBGC would get the right to pursue them. And so it would be their decision as to whether or not they wanted to pursue. That's the way that they would offset how much money they have to pay out to the pension holders. So if they took the $86 million and they had to put in another $85 million, they'd want to find a way to reduce or to get reimbursed back some of that money. So they would take every claim that we believe we could pursue, they could pursue. I just don't know whether or not they actually would. I would not have the ability to control that, either with the court and either with special counsel.
Another question, I just didn't understand the article about the $8 million.
On the Rhode Island Foundation?
Right, was that taken out of our pension?
No. So when the hospital went through its conversion of a not-for-profit to a for-profit, the for-profit entity cannot administer the charitable funds. So people donated money to St. Joe's and said, I want you to use this money. Some said, use it for whatever you want to use it for, and some said, I want it specifically used for this, whether it be the nursing school or something. The funds that they said, here, I want to make this donation to St. Joseph's, use it for whatever you want, that money went into at the time of the conversion, it went into St. Joe's operating account, its general operating account, and was used to pay down, and is continuing to be used to pay down the debts of that entity. So that entity is still in its wind down phase. What the Rhode Island Foundation got were monies that were designated after a review, and I'll explain the review as quickly as I can. But they went to the Rhode Island Foundation after a review which determined that they were what we call restricted funds, meaning a donation that has to be used for a very specific purpose. And if the hospital can no longer achieve the purpose of the intended donee, then it has to go to an organization like the Rhode Island Foundation, which can help to put that money in the hands of somebody who is identical to what the original donee intended, or as close to what the original donee had intended as possible. That restricted fund pool, which was about $8.2 million, is identified in the first instance by St. Joseph's Hospital during the conversion process. So they say, here are the restricted funds that we have. That goes to the Attorney General's office. The Attorney General then reviews it to make sure that they agree that the funds that the hospital is saying have no restriction really don't have a restriction, and the ones that do really do have a restriction. Then all of that is presented to the court in what's called a cypre petition, which cypre means literally as close to as possible. And the court makes a determination as to the fact that those funds are restricted, that the donee intended them to be for a very specific purpose, that the hospital can no longer meet the donor's intent, and that there needs to be another organization or entity that can serve as the vehicle to get those funds to match what the donor's intent was as close as possible. That's the 8.2. The reason why I'm looking at it, and the reason why it's connected to this pension, is because, quite frankly, in this case, I'm not really trusting anything anybody did before I got involved. And with no disrespect to the court, that means even the court. The court entered an order, but the court relied upon the Attorney General in St. Joe's for the order that it entered. I don't necessarily trust that what they did in their review was what I agree with. So I'm looking at it. If I believe that some funds went over to Rhode Island Foundation that should not have gone over to the Rhode Island Foundation because they were called restricted but they really weren't, or if I can make an argument that they shouldn't have been restricted because of the circumstances of this pension, then I'd be asking the court to vacate or modify its prior order and direct the Rhode Island Foundation to send that money back to me so I can put it into this plan. I may not be able to get any of that money back. I may be able to only get some of it back. But it's one of those things where it's $8.2 million. It's not an insignificant amount. And if it's possible to make an argument that at least some of it comes back, I'm going to take the chance.
Okay, thank you.
Each one of these meetings gets shorter. Any other questions? Not yet, because as I stated, the judge is still out sick, so I won't be able to reschedule what was supposed to be heard Friday until he gets back. And it's likely, depending on how long it takes him to get back, It's likely there might be one or two other pleadings that join that one. So there may be more things heard on the next hearing date than even we were expecting today. So, but once I know the date, I'll be posting it on the website and letting everybody know.
How long can the other entities keep Stonewall?
At this point, not anymore. All of the ones that have sought to delay or limit what we requested, we went into court and we dealt with on motions to compel, and the judge was very quick to rule in our favor and set very hard deadlines. There were deadlines for some, the deadlines ran at the end of December. I think the Attorney General had until January 15th to fully comply. Everybody else who didn't go before the court on a motion to compel didn't go before the court because we agreed with them. They finally came to an agreement with us outside of court as to what their deadline would be. The ones where the court acted, they actually not only got a date certain, but the judge required all of them to file regular reports. In some instances, the reports had to be filed every 3 days to give the court a status of their efforts. The court was not very tolerant for the delays. And I think that after those first few motions to compel, the rest of the parties that received subpoenas probably wisely decided that it would be a good idea to just enter into a consent agreement with us rather than go before the court and explain why they weren't producing. So we're still getting information in. We haven't gotten everything in, but we have about 500,000 pieces of paper. So it's safe to say that we've gotten the bulk of what we've asked for, but it does not mean that there isn't an ongoing obligation to continue to supplement. And there are still discussions going on with documents that parties are saying are confidential or privileged, and we're dealing with that piece right now as well. So the reason why Max and his team have been backed up by 45 days or so is because of the delays that occurred back in November. But we're past that now, and now we're in the review portion of things, which we had hoped to have been done with by now. But I think we've got, although, again, we haven't gotten everything, what we're waiting for, we've agreed we can wait for a little bit. For example, the Rhode Island Foundation asked for an extension, and we voluntarily entered into an agreement with them for a slight extension, not what they were asking for, but further out than the actual deadline that we had originally set. So we're still collecting documents. But everybody is, at this point, there's nobody out there that is still stalling. If there were, we'd be in court. Any other questions? I guess if there are no questions, I will just say, as I stated before, the advisory committee, which is made up of about 16 people. 20 if you include the lawyers, which a lot of people don't like to consider us, so about 15 people. We do meet regularly. It is I could tell you that I believe the meetings are generally very productive, a lot of good ideas. As I would expect, sometimes there are tempers that flare, so the people that are involved in these committees and in that committee are passionate, and 15 of them are what I believe a good cross-section of the pension holders, which are you, and they all have very, very good ideas, and hopefully, if we get to the point where something needs to be done, I am happy to say that at least the group has shown both a willingness and an ability to be very creative. So we're talking about lots of different things that aren't necessarily cuts to the monthly amounts, but different ways that we can manipulate things so that maybe the monthly amounts don't have to get cut. Hopefully we won't have to cross that bridge, no promises. But that group, I appreciate their work. I appreciate their dedication. We've been meeting very frequently, and I believe that I think I've had almost perfect attendance from everybody, so people are going to the meetings. Nobody is, there's an obligation, they have an obligation to each one of you, and they are all doing everything that they can do to help with that process. I appreciate them, and you should as well. Any other questions? Anything at all? Marilyn?
I just want to address, I received a lot of phone calls this week since everybody got their March 1st checks, that there was an increase in the amount of benefits for everybody, and people are asking why. Am I correct? Not everybody got it, okay? Not everybody received it. Am I correct in saying that's related to the president's tax cuts?
I believe so, but I will confirm that. Okay, and I'll, similar as the other question, I will add that to the frequently asked questions.
It's not a lot of money, but
Okay.
it's an increase.
It's the first time I didn't think I would get a question from anybody about getting more money. Any other questions? If not, as usual, I will be here if you have some specifics, but thank you all for coming out. I appreciate it. Thank you.